Welcome back to Good Law, Bad Law. My guest on today's episode is Temple Law School advocacy professor Jules Epstein. Jules has been a trial lawyer in Philadelphia for more than 40 years and has become really nationally known for his work on eyewitness identification in criminal cases, something that most of us would think is kind of obvious when someone says they were an eyewitness and are able to point to the perpetrator, or even in a civil case where witness identification becomes important. But it's a lot more complicated than that, and there are a lot of ways that an eyewitness's testimony can be flawed, even if not for some evil intention. So we're going to talk about all those issues and some specific cases where people have been freed from jail after a long, long time in prison based on faulty eyewitness testimony. So there's a lot of ground to cover with a really captivating and knowledgeable expert, Jules Epstein. So stay tuned for this great episode of Good Law, Bad Law. On today's episode, we're continuing our exploration of issues in criminal law in particular, and also continuing back-to-back weeks with former professors of mine at Penn Law. So I want to welcome my guest today, Jules Epstein, who taught me evidence in law school and also teaches now at Temple's Beasley Law School in Philadelphia. Jules, thanks so much for being on Good Law, Bad Law.
What an honor, and thank you for doing this program.
Thank you. This is really a great topic we're going to be taking on today, the issue of eyewitness identification in criminal cases. And I know this is something that's been of great interest to you in your teaching, in your work, in your practice as a criminal defense lawyer. And we have something of a news hook to the story that we'll get into as well. But tell us a little bit about your own background, Jules, and how you came especially to focus on this particular issue of eyewitness identification.
Sure. So I've been an attorney since 1978 and started out in criminal law as a public defender. And of course, some of what you get there are cases where your claim is that the witness is honest, in other words, not lying, but mistaken and has picked the wrong person. And so it's part of the daily grist of being a public defender or anyone in criminal law. I began researching this in depth when I became a full-time academic. And starting in maybe 2006, so I guess 13 years ago, I've written several law review articles. I have served on two commissions on eyewitness identification. I've testified as an expert on eyewitness identification in two different types of cases. I've trained lawyers, and that's prosecutors, defense counsel, and I should add here, lawyers in civil law. I actually gave a lecture on this to insurance company lawyers because what people saw and how well they saw it is a big issue there also.
Right, sure.
Most recently, I've done training with prosecutors and detectives because I think that's where my time is best spent. I've worked with the local, meaning Pennsylvania Innocence Project, on 3 or 4 cases where I review the cases if I think there are eyewitness concerns and write a report for them and help them reinvestigate it. And I've been involved in 2 exoneration cases where eyewitness testimony was at issue. One where I was the lawyer at the time of the exoneration. One where I was the lawyer who lost the case. And happily, the Innocence Project picked it up
Yeah.
and was able to convince the prosecution and the courts that an innocent man was in jail. So a lot of time, a lot of thought about this.
Well, and I want to focus on some of those specific cases as we get deeper into this. But I have to say, it is one of the surprising conundrums of criminal law and civil law too. You're right. I mean, even a simple car accident in an intersection can involve all kinds of questions and problems of eyewitness testimony. But it seems like it should be something so clear cut in a certain way, because if somebody is being honest and they did see something, then that would seem to be pretty compelling evidence in any case. But of course, there are a lot of issues. And, as we get into this, how would you outline what some of the bigger concerns are when using eyewitness testimony? Where are some of the ways that it can go wrong, leaving aside someone who's just lying, because that's not really a function of the quality of their eyewitness testimony itself. That's
The
a whole other thing.
most important thing to understand, and maybe the two most important things, are number one, the human mind does not work like a video camera. And I'll elaborate on that in a minute.
Mm-hmm.
The second one is that, and it's an imperfect analogy, when police collect eyewitness evidence, just like if they collected a fingerprint or DNA, they have to be careful how they handle it. Because unintentionally, and indeed even with the best intentions, they might actually contaminate the memory.
Mm. How so? I mean, is it by the way questions are asked, or by I mean, that's a pretty strange concept. What do you mean by contaminate the memory?
All right. So can I take a step back and explain the memory part first? All right.
Yeah, of course.
As I said, I've been a lawyer for 41 years and a couple of months. And in every case that I defended or that I reviewed involving an eyewitness, the eyewitness would claim, the prosecutor would argue, and many times the jury would believe the famous words, "I'll never forget that face."
Mm.
Right? And it is true that the victim, or sometimes the eyewitness, will never forget the event. But that's not the same as the details of the face.
Yeah.
Right? Someone who's been robbed or raped or witnessed a gruesome murder won't forget. Just like all of us, at least of my age and your age and a lot of other people, will never forget September 11th, 2001. But if I were giving this as a lecture right now and we had an audience, I'd start testing people on details of September 11th, 2001.
Mm.
Which tower was hit first?
Yeah.
Which airline was it? We all knew that in the first 2 days.
Right. We couldn't stop talking about it. Right.
But we won't keep those details. And by this time, we may have wrong details in our brain. And as we go on in this conversation, I'll be happy to talk about the research in a number of areas. But if we understand, and when I say that it's clear that memory is not a video camera, it's not just me saying this. This is established science for 100 years. And any vision or memory scientist you will talk to will tell you that memory is a process. It's not so different from writing a document on a computer and then going back and editing it and then editing it again. By the end, your final document, your final memory doesn't always look the same as your original.
Mm.
So when we observe something, first of all, we don't get all the details, and we may not get the details that we do get correctly.
Sorry. Go Well, no, I was going to say that the impact of the development of science seems so important here. I mean, there are classic examples of eyewitness testimony going wrong. I mean, I think one of the funniest movies ever is the movie My Cousin Vinny, and Joe Pesci cross-examines the so-called eyewitness who gets it wrong because she was wearing her glasses at the time, and it turns out her glasses were, Coke bottle thick glasses, and that impaired her ability to actually recall. But the joke aside, there are a lot of ways in which the science, you're stating something in a lay sense, but it's a scientific issue that the mind and the memory isn't like a video camera.
Right.
And that there are things scientifically in the way our brains work and the way our memories work that affect how we recall what we think we remember. Um, so, but that's not a new issue either. I mean, 40 years of being a trial lawyer, uh, but I'm wondering if the development of DNA evidence is what has been so helpful in demonstrating and being able to demonstrate the potential pitfalls or flaws of eyewitness testimony, because you can exonerate somebody based on DNA to prove that they didn't commit the crime, and then work your way backwards to show that the so-called eyewitness testimony was flawed in some way.
Right. So there are two developments in the world of DNA that are critically important to, if you will, elevating the concern about eyewitness testimony.
Yeah.
The first goes back to the Clinton administration and then Attorney General Janet Reno. After the first 26 or so DNA exonerations, she ordered a study, and anyone listening can simply go on the web and use any web search engine and type in the words "convicted by juries, exonerated by science."
Mm.
And that's a government report that Janet Reno commissioned with sort of a blue ribbon panel that looked at each and every one of those early DNA exonerations.
Mm-hmm.
And it was an early call that one of the problems, there were other problems in those cases, but one of the recurring problems was eyewitness testimony. Add on to that the development of the National Innocence Project, Barry Scheck and Peter Neufeld up at Cardozo Law School in New York, and then various state and regional innocence projects. There's one here in Pennsylvania.
Mm-hmm.
There are lots around the country. And you get data. And it's remained fairly consistent that if you take the DNA exoneration cases, it's between 66 and 70-something%, 2/3 or more, included at least one wrong eyewitness.
Mm.
Let me add something to that. Those numbers mirror a study from 1906, before there was DNA as a tool for an exoneration. More than 100 years ago, there was a guy named Borchardt who worked for the United States Library of Congress. And interestingly enough, he wrote a report on wrongful conviction.
Incredible.
He had 60-something cases. 2/3 of them involved mistaken identification. So the phenomenon has been acknowledged. The reality is when you have DNA that says, I don't care how much this person is saying, I am certain. The DNA is saying, you are wrong.
Yeah.
Really shook people up. So you're right. DNA changed the conversation.
Mm. Well, let's bring in a specific story, and then I want to try to understand some of the ways in which eyewitness recollection can be honest but flawed. And there's some pretty significant ways in which we could understand that. But I think the importance of this, outside of the theoretical interest, is that it has real impact on real people.
Right.
And it was reported last week, and I think this is, as you'll tell us, one of the cases that you yourself worked on, the case of Willie Beasley, who was freed after 27 years in jail serving a life sentence. He was ultimately exonerated of the crime through the work of the Pennsylvania Innocence Project. And he is according to the article I saw, he's the 8th Philadelphia man sentenced to life in the late 80s or 90s who has been exonerated and set free this year alone. The 8th person. So that is just astonishing. And that's just Philadelphia. So what can you tell us about this case, and how does this fit into the issue of eyewitness identification?
So Mr. Veazey's case is not one with DNA.
Okay.
But we'll get to why that didn't matter in a couple of minutes. I was appointed to represent Mr. Veazey in the early 1990s. There was a murder in a section of Philadelphia called North Philadelphia. Months go by, and due to some investigation, Mr. Veazey was named as a suspect, primarily through an eyewitness named Denise Mitchell. The police arrest Mr. Veazey, and within about 3 hours have a confession out of him. The problem was, on the January night when this happened, Mr. Veazey had a time card showing that he was working as a dishwasher 8 miles away in a suburb outside of Philadelphia.
Wow.
But it was the power of a confession. And back then, we did not have video recordings to see what happened in that interrogation room. And the power of an eyewitness that together overwhelmed the jury. Although even with that, they spent 4 days deliberating before convicting.
Wow. And a whole issue of confessions that are flawed. I mean, that would have to be a whole separate episode and conversation, because there's a lot to that. But the eyewitness identification part of this, well, if he wasn't cleared based on DNA, how was he ultimately exonerated, Mr. Beasley?
There were two basic grounds for that. One was an investigation of some other cases disclosed what we might politely call potential police misconduct in Mr. Veazey's case that had been not disclosed. And the second is that the prosecution actually hired its own expert to assess the confession, the technique, and the resulting product, and decided this is not a good confession. And Willie's alibi was compelling.
Yeah.
I mean, I cannot tell you how stark it was being in a courtroom where a detective is saying he confessed. And we caught the detectives in a couple of pretty clear misstatements. And I had a time card.
Yeah.
Where nobody had a reason to fabricate it. But anyway, that was confession plus an eyewitness.
Well, that gets to an interesting and really important part of this conversation, which is not just the way the witness or the claimed eyewitness, the way his or her testimony can be flawed, whether it's distance away from the event, whether it's problems recalling the details of the event. There can be all kinds of problems in the way a lineup is put together that can influence the validity of an eyewitness's testimony. But then there's this whole other aspect of this, which is the way a jury can weigh and understand the eyewitness testimony that they're receiving in a trial. And there must be ways, I would think, and I'm curious what you think of this, but there must be ways in which juries can be biased, despite our best efforts as trial lawyers to teach juries how to think in a non-biased way. I mean, people are human beings. So in the case we're talking about, you had what seems like an extremely compelling alibi, and yet the jury believed or weighed more heavily the evidence of the eyewitness and presumably the confession too. So
Right.
how does that play into this, the fact that we're dealing with juries ultimately and how this evidence is considered?
So there are maybe 3 or 4 responses to that. One is, in some jurisdictions now, the courts have approved elaborate jury instructions so that the judge is saying to the jury, I need to tell you some of the science and how eyewitnesses might be mistaken.
Mm.
In some jurisdictions, actually in just about everyone in the country, I think there's one state that currently disallows it. You may bring an expert witness. It's usually a psychologist, a researcher. In one case, I did this because they had nobody else, and I know it pretty well.
Oh, you served as an expert witness.
I served as an expert witness in a homicide trial in Harrisburg, the capital of Pennsylvania, earlier this fall.
Mm-hmm.
I guess it was late summer, early fall in September, and got to come into court and do sort of what I'm doing now.
Yeah.
Which is, the expert does not say this eyewitness is right or this eyewitness is wrong. The expert says, let me give you some basic science so that you, the jury, can evaluate this more objectively.
Right.
There's a third thing, and I do a lot of training of defense lawyers, prosecutors, and detectives on this. That much more important than a person's words are recreating the crime. If people go to the corner where it happened, at the time of day or night when it happened, with the lighting that was present when it happened, and act out the crime step by step, and stand across the street or down the block or wherever the eyewitness was, we are much more likely to get an accurate idea of how good or not good a look the eyewitness had. And sadly, too few lawyers do that.
Yeah.
But when you can bring the crime into the courtroom, so to speak, it makes a radical difference.
Well, and of course, as the prosecution's interested in one thing and one thing only. By the time they get to trial, they're interested in getting a conviction. So they're not gonna voluntarily get into some of the ways in which an eyewitness's recollection could be flawed. That's defense attorneys got to understand those things. It's a matter of life and death for the defendant to be able to understand that science.
Well,
Yeah, sure.
I just want to jump in. By the time of trial, you're right. But the real goal in all of this work, and the work I'm doing of late, is to get the prosecutors looking at the case through the perspective that eyewitnesses sometimes are right, but sometimes are wrong. Let's really assess the risk in this case before we get to the gladiator stage of trial.
Yeah, yeah. I mean, do you find prosecutors, DA's offices are open to this? Because I mean, they don't really. I mean, it's hard to imagine there's a human being who actually wants to falsely convict somebody. I mean, they don't want to face that.
Correct. And
So
they want to make sure that that they get the real person, because if they're doing the wrong person, the real doer is still out there causing all sorts of problems. So there are many prosecutors' offices and many good police departments and many law enforcement organizations. One is the International Association of Chiefs of Police that train people on the risk of eyewitness error to try and catch it before it happens.
Hmm. Well, I want to ask you about one last area of this, Jules. You did send me. What's that?
Go ahead. I didn't say anything.
Oh, okay. I'm sorry.
I don't know what you heard.
Oh, I don't know. I heard a click or something. So you sent me a PowerPoint that you've used in some of the seminars you've given, and one of the slides really caught me, which is which gets into the issue of racial bias when it comes to eyewitness identification, and it's pretty compelling that the in exoneration cases where there's been an eyewitness uh, involved in the conviction, where there's then been an exoneration, you can go back, as you pointed out. The more and more cases you have, the more data you have to work with, and try and understand what went wrong, and hopefully what to do about it. But one of the data that you look at is the race of the exonerated defendant in cases. I think these are cases involving DNA, where DNA was part of the exoneration, is overwhelmingly African American, and the race of the victim in these cases is overwhelmingly white. So,
Right.
I mean, that clearly points to, whether it's correlated or causative. I mean, it points to some really powerful racial imbalance in these cases. What do you, I mean, what's your view on that?
So I'm going to use the word bias, but I want everyone to understand that the word bias is not the same as prejudice.
Mm-hmm.
A prejudice is, I don't like you because of your race or your gender or your whatever. Bias is something that's going on in the background in our brains that makes me lean one way or another way without thinking about it. The scientific research, and it's been around and it's continually being reproduced, is what we call own race or cross race bias.
Mm-hmm.
Some researchers calls it the in-group and the out-group, because it's not limited to black and white. But the basics, and this has been studied around the world. When I testified as an expert earlier this year, I talked about a study in Ukraine
Wow.
where they're talking about the ability of Ukrainians to identify other Ukrainians better than Chinese people or people from India or people from Africa. Even in a world where there is more and more integration, we tend to do better at understanding and appreciating the differences in facial appearance in people who are like us than in people who are less like us.
Mm.
I'm a white male. There's a fair amount of variation in hair color among other white people. There's less of a variation of hair color, at least growing up for me, there was in Asians or African Americans.
Mm-hmm.
So I'm a guy who grows up used to using hair color as a way to help distinguish one person from another. There are lots and lots of studies that you do better. So here are the numbers. The chance of a mistaken identification is 1.5 times greater when the witness and the perpetrator are different races. And this can be black, white, it could be white,
Mm-hmm.
Asian, it could be Asian, Hispanic, whatever, than when they are both of the same race.
Interesting.
And it gets worse because if other factors, reduced viewing time, or the longer the time between the original crime and the first identification,
Mm.
when those other, what I'm going to call negative factors are present, the racial disparity gets even worse. So,
and then and there are so many other variables too. I mean, there can, if you're a victim versus a bystander, if there's a weapon involved, if there's a gun involved. I mean, there are different the way the lineup is put, the way a photo lineup is put together. You point out that if the people in the photo lineup are wearing hats, that can obscure the not just hair color, but the amount of hair, the hairstyle, and all kinds of things. So there's a lot of ways that these things can be flawed without necessarily there being an evil motive behind that. But when you're talking to prosecutors' offices, when you're talking to defense lawyers, I mean, this racial bias, and I understand your point about the difference between bias and prejudice, but nonetheless, there it is, based on the data. What can be done about that?
So the answer is a couple of things. First of all, please understand that an eyewitness could be of a different race, have limited time to see. Yes, there was a gun present, which increases stress and takes the victim's eyes away from the perpetrator's face and to the gun. Because I don't know about you, but I'd be looking at the gun, right? I'm afraid of being shot. All those problematic factors could be present, and the eyewitness could still be correct. So what it really means is this: when those factors are present, you just have to be more cautious and look for other evidence, corroborating evidence, because otherwise you're flipping a coin. Gee, is this witness right or is this witness wrong? There is no objective way to tell. So to me, one of the main lessons of the factors that impact negatively on eyewitness reliability is know them. When they are present, proceed with more caution, and also do better investigation. There's one other thing, if I may, that I want to add to that.
Yeah.
So the scientists who've been studying this, and now I'm going back, 35 or 40 years, have labeled those factors into two categories. One they call estimator variables: the lighting, how quick or long the crime was, how much stress. Those are things that the crime circumstances and the criminal control. But there are also things called system variables: how the lineup is constructed, who runs the lineup, how the witness is debriefed. There's been a ton of study about what we'll simply call best practices. So what are best practices? They are the system variables which, when done in a certain way, reduce the risk of mistake. So the big lessons here for the prosecution and the detectives are: know when an eyewitness case is maybe questionable, and then use every system tool, right? The right lineup instruction, in the best way, so that you don't make things any worse. And so that then you're getting a better measure of, is this person really picking this guy or this woman because that's who did it? Or is it because I ran a bad lineup? Let me give you one quick illustration, if I may. So when I teach this, I show people a video of a crime, and then I show them a lineup. What they don't know is that the criminal is not in the lineup. But they all look sort of like the criminal. Well, I can give two different instructions. Instruction number one is, please look at this lineup and pick the perpetrator.
Right.
Or I could say, please look at this lineup. The perpetrator may be in it or may not. If you think the person is, tell me who you think it is.
Yeah.
In my first instruction, I've implied the perp is there.
Right, for sure.
In the second, it's like a multiple choice test where I've said it's okay to answer none of the above.
Right.
The difference in instruction affects the number of wrong selections.
Amazing.
So if you can do the best police practices, we will reduce the risk.
Well, and you brought up something that made me think, even though I said one last question, I just thought of one last thing that I want to ask you, because we kind of started this conversation, interestingly enough, talking about the science of this. As a layperson, you might think, oh, someone says, I saw what happened, and that's the person that did it, and that's all there is to it. But there's an awful lot of science to this, as you pointed out along the way. And I'm wondering, as brain science itself continues to advance, I mean, as the technology to look inside the brain with different types of MRI technology to see the brain actually at work on live images through certain MRI technology, do you see a time where brain science advances to the point where you could actually test? You said it's hard to be objective about certain things, but I'm wondering if there's a point where you could get to with development of brain science where we could actually make some objective determination about the probability of an eyewitness's testimony.
So,
based on studying memory, based on studying the impact of whatever stresses were present, and try to objectify that in some way.
So at the moment, the answer is no, with one tiny maybe. And here's the tiny maybe. There are some people among us who we call, super eyewitnesses.
Yeah.
Okay, super identifiers. All right. And in fact, in England, they test people to see who have that capacity and bring them in to work in the police department because they are unbelievably good at what we call facial recognition. The term, and I stumbled before, is we call them super rememberers.
Yeah.
But that is done by administering a battery of psychological tests, what are called facial recognition tests. So there are some people out there who, if 3 years from now say, hey, you're the waiter who served me that terrific hamburger 3 years ago, they'll probably be right because their brains are wired that way. But we don't, when witnesses come into court, say, excuse me, come into the other room and we're going to spend 3 hours or how many days administering facial recognition tests. So yes, there are some super rememberers. Then there are people like me. I am the world's worst at remembering faces. I'm terrible.
Right.
So we have that spectrum.
Well, I have that problem, and it's not getting any better as I get older.
Right.
Which is another factor, of course, in all of this. Well, fascinating stuff, Jules Epstein. Thank you so much for being on the program. Jules teaches advocacy and evidence at Temple's Beasley Law School in Philadelphia. Has also taught at Penn Law School, where I went to law school. Has practiced as a trial attorney for 40 plus years. Lectures, teaches, more distinguished teaching awards than he is too proud to brag about, but we know it's there, and really an expert on this topic. And so thank you very much, Jules. It was a great pleasure to have you on the program.
Thank you for doing this. It's really important to teach people.
Yes, thanks again.